going to be held.
This is their
You must
total.
have annexed with your application.
After filing application.
No, my lord, after
Why not?
no, my lord, because at the time of filing, or this was filed in 13th of January, this application could not be taken up, my lord. It is subsequent.
Then this should have been brought on record. How will your other side get to know?
It is their website. From
They
their
will have so many things in the website.
my lord.
That doesn't mean that the council will know everything. The university may know it.
My lord, I'll hand over a copy to him.
Show it to him right now.
আপনাদের website থেকে 2nd of March থেকে schedule.
My lord, on this I shall take instruction. Because my lord kindly sees his prayer in the application.
I am not going to the application. He prays that the examination is going to start from Monday or something, or the last date for filling in the forms is such.
Yes.
It is only for this reason. Otherwise, 2nd March there is time.
This is first internal class test.
Yes.
So it's a test.
It's a test.
When will it be held?
2nd of March.
2nd March.
Schedule
And
has-
for that, the fees are to be submitted prior thereto.
Yes.
Come at 1 o'clock prior to recess.
Yes, my lord.
Take instruction.
Yes.
And see what I am thinking of. I'll make myself clear so that you can take instruction. The similar direction that was passed in December, paragraph number 9, he may be permitted without any right, equity, nothing of the sort. And he is not going to attend classes. If online, you permit him to put in the fees and he will appear in the examination. Either it is online or offline, I do not know. Only this. Speak to your client. I'll take it up prior to recess.
Grateful.
And as far as the criminal case is concerned, my lord, it is pending.
That is nothing to, we are not paying anything against the criminal case.
Your lordship. Your lordship. Can I mention one important matter? I'm sorry. At similar matters, my lord. 4 colleges are before your college lordships, my lord. These colleges are, my lord, imparting, my lord, D-Farm education to the students.
What education?
D-Farm,
All right.
Diploma in pharmacy.
And pharmacy.
having 60 students in each college, 60 number of students, my lord. 60 number of students. I'm sorry, my lord.
3 to 6.
Let us, my lord, concentrate on item number 3, my lord. 3 to 6, my lord. I'm sorry. My lord, each college has, my lord, 60 number of, my lord, vacancies, my lord, for imparting the D-Farm education. Now, my lord, the petitioner in item number 3, my lord, started, my lord, imparting the D-Farm course on and from, my lord, 2022 upon obtaining the consent letter, my lord, from the respondent number 2.
Is the pharmacy council?
Pharmacy council is there, my lord. This is my affidavit of service. My lord.
Yes, then.
Now, my lord, page number 21 is, my lord, the consent letter. That is, my lord, a mandatory, my lord, in which the petitioner or, my lord, the colleges who are interested, my lord, to run the D-Pharma course has to obtain a consent letter from, my lord, the West Bengal State Council of Technical and Vocational Education. Now, my lord, page 20, the last paragraph, my lord, may I read below? The West Bengal Council of Technical and Vocational Education and Skill Development has no objection for issuing consent of affiliation to the above named institution related
Last paragraph.
to the page 20, last paragraph.
Yes.
Has no objection for issuing the consent of affiliation for the above named institution related to opening of new diploma courses subject to the grant of approval of the Pharmacy Council of PCI India under section 12 of the Pharmacy Council Act and subject to Milord physical inspection and verification of infrastructure and Milord facility at the time of grant of affiliation. So Milord, whatever affiliation or Milord approval is being given to the petitioner is based upon Milord section 12 of the Pharmacy Council Act, Pharmacy Act, and that has to be given upon verification. Now Milord, here verification is restricted to Milord two things. One is infrastructure and Milord the facility. These two are the mandatory things. This is Milord issued in the year 2022. And Milord, subsequently I obtained the affiliation from the Pharmacy Council of India, Milord, which is at page 21. This is Milord for the session 23-24. Thereafter, Milord, once again my affiliation was renewed by the West Bengal State Council of Technical, Milord, and Vocational Education for the session, Milord, 23-24, because Milord, every session I have to renew. So this entire process, Milord, is absolutely based on led by Mr. Shengupta. Let him. But every year, Milord, I have to Milord obtain a renewal from both the State Vocational Council as well as from the PCI. Now, Milord, this renewal, Milord, was continued up to the session, Milord, 25-26 by the Pharmacy Council of India, which is Milord in terms of section 12, which is at page 25 annexed B3. Now, Milord, what has happened? All of a sudden, on 16th of January, Milord, the petitioner was Milord handed over or issued with a notice which is under challenge by the West Bengal Skill Technical Development, citing Milord that I have certain number of deficiencies and accordingly they cannot renew my affiliation for the session 25-26. Whereas for the past sessions, Milord, they have in tune with the PCI have renewed my affiliation. Now may I place Milord the deficiencies that has been Milord mentioned. There are 6 number of deficiencies which includes building, infrastructure, laboratory infrastructure, essential software, library books and academic activities. Now Milord, once again Milord, may I pause and may I Milord take your lordship to Milord page 20, which is Milord the initial Milord consent letter by the technical development. Milord, it says Milord subject to physical inspection and verification of all infrastructure and facilities. So Milord, these deficiencies Milord at page 26 is within the meaning of Milord infrastructure and facilities. Whereas from the inception of opening the college, both the council and the skill development Milord, the respondent number 2 and 3, they have time and again Milord renewed my affiliation. Whereas for this session 25-26, they have not, on Milord certain purported grounds Milord, which Milord cropped up on the basis of alleged inspection, that it says, however, it has been observed from the inspection report, no report was handed over to the petitioner of your institution that there are following major discrepancies, deficiencies, disputes in the infrastructure or other facilities required to be conduct the course. Now, Milord, in response to this the order, Milord, the petitioner has given Milord a reply which is at page 27, which is dated 27th of January. That each and every deficiencies has been dealt with by the petitioner. Now, Milord, they say my name of the college is not properly displayed. Now, Milord, will kindly comes to page page 34. They say the name of the college is not displayed. They say I do not have a completion certificate. They say I do not have an insurance of the building.
Was this picture there on the date of the alleged date of the inspection?
Yes, because this is something which is not newly affixed. Kindly sees the name Nobipur Navajagoran College of Education. This is something painted in the wall.
The date is important, my lord.
The date is important. Absolutely. This picture was taken on 26th of January. The latitude, my lord, everything is there. Now, my lord, with regard to the insurance, which they have, my lord, said.
Building insurance certificate not available.
It is there, which starts from, my lord, page 29 onwards.
All right, I get it. Page 26 is the impugned order. These are the deficiencies for which they have refused affiliation, for which you have.
This is only by the respondent number 2 and 3.
Right.
The respondent number 4 has already removed my affiliation.
25, 26?
My lord.
Show me, please.
My lord. It is at page 25, annexure P3.
Yes, 25, 26.
25, 20. They have approved. Well, may I read the decision? 428 EC.
Yes, I've read it.
Well, Mr. Shengupta will email address.
Yes, yes.
My lord, may kindly takes up page 44.
Is it your case that no inspection was conducted?
My kindly takes up page 44. To answer to your lordship, this query only.
Yes.
This is an application form for pharmacy for academic session 25-26. This document has been generated after I have submitted the application for removal of my affiliation. But the date is very important. This 12th of November 2025 at the very bottom of the page, my lord. The next page 45. And the second column which says approval. Page 45, approval, in that column date of last inspection was on 11th of October 2023. Now, my lord, may kindly comes to my lord, page 49. Or page 48 first, my lord. Kindly comes to page 48.
Yes.
These are all the details relating to the faculties and the facilities. And after I will input all the details, kindly see at the bottom of the columns, confirm if this above given data by the institution is correct. Yes, Tausif Jaman was absent during this inspection. Second column, yes, physically verified. Is all this column, it will be said that yes, verified, they are submitted.
Who has mentioned this physically verified?
On the website of the university, my lord, the affiliating body.
The affiliating body.
At the very bottom, the name is a WBSC SCTVESD. And all the deficiencies that they have pointed out in this application, my lord, the appraisal of this application will show that they have verified that we have submitted all the documents to their satisfaction. Madam, kindly takes up page 51. Action. Page 51, the first column relates to page 50, department-wise list of minimum equipment required for D-Pharma course. Confirm if the above given data by the institution is correct. Yes, verified. So was this verification only?
Do you all put in only the data and the whether yes, verified, confirmed?
Data along with corroborative evidence.
All right. And this confirm if the data is correct or not, the remark is given by the university?
Yes.
The council?
Yes.
All right.
Documents submitted. But kindly takes up page 58 also. Status absolute. Completion certificate.
Yes.
Documents upload list. Kindly see, building completion certificate. Serial number 2. Building insurance certificate.
And every year you are supposed to give this building completion certificate.
Yes.
All right. Uploaded.
This is the year-wise renewal, my lord. Confirm if the above given data by the institution is correct. Yes, verified. And next page is the signature of my lord. Kindly see page 59. Signature of with the seal of head of the institute. Signature of inspection officer 1. Signature of inspection officer 2.
All right.
But can page 58, 59 or the entire application subsist with page 26?
All right.
And
What is the course fee? 2 years course.
2 years course.
What is the course fee?
It is 70,000. The act prescribes 70,000, but in
2 years.
for 2 years. But in our state, due to lot of institutions are there, we don't get 70,000. It is approximately 45 to 50.
You all negotiate fees?
It varies from college to college. It differs from college to college depending upon the area and all these things. The ceiling limit is 70,000. You cannot charge more than 70.
All right.
Even the NCT courses, the B.Ed courses, you can't charge more than 1,50,000.
My lord, in this matter, I am appearing for the Pharmacy Council of India. I have a very limited role. Backdrop, I must say, my lord.
Because he has not made any allegation against.
No allegation is the
At
PCF.
certain points, being an officer of the court, I must raise certain issues, my lord.
Very well.
Before 2020, there was a moratorium. West Bengal number of pharmacy college was increasing. There was a moratorium put by Pharmacy Council of India. Subsequently, moratorium was waived in terms of the order passed by the Honorable Supreme Court. And after that, there was a mushroom growing of pharmacy colleges in West Bengal. All B.Ed colleges, due to the education thing, all B.Ed colleges was transformed into pharmacy colleges. What happened? Pharmacy Council of India is the apex authority that is admitted, subject to approval of the state authority, because we give the affiliation and state is the authority to conduct examination and other things. This particular point was raised in a matter.
What point?
Role of Pharmacy Council of India and state authority.
He is not saying anything about her role.
Pointing out, Mark. What I'm pointing out, need to point out, Mark. And the Honorable Division Bench was pleased to pass one order, Mark. Almost same self issues, Mark. I am placing some almost on the same self issues. That Pharmacy Council of India has granted permission.
All right.
State did not grant permission.
Okay.
Mark, kindly comes to page number 8, Mark.
Yes.
Error number 12. My submissions have been recorded. Mr. Bondamada appeared in the matter, Mark.
Yes.
It is submitted by the Land Council and such for the Land Council for such that while the college may be overly anxious to admit students in the M.Pharm course, absence of any necessary infrastructure would harm the interest of the student and consequently the stature and standing of the PCR and university in awarding degree to otherwise unqualified, improperly trained student. Future of the student and training of the student is a paramount consideration because pharmacists are very important now. Next, Mr. Bondamada submitted. And page number 9, my lord. Submission of Mr. Bondamada is there, my lord. Section 12 has been quoted. Subsequently, the finding of the court, page 10. Paragraph 16. Onwards, I am placing, my lord. The court has carefully considered the argument of the appellant colleges, PCI and MACOUT. At the outset, the court notices that the learned advocate for the PCI itself was in support of the contention of the MACOUT. The PCI in essence agrees with the view of MACOUT that existing infrastructure of the appellant is insufficient to commence the M.Pharm course. With the view of appropriately address the argument of the learned senior counsel for the appellant, one must notice section 12 of the Pharmacy Act 1948. Section 12 has been quoted, my lord. Next paragraph, 19. It is clear and explicit from the subsection 1 of the clause 12 of the first limb of the approval by the PCI comes at the instance of the institution which wishes to conduct pharmacy education, graduates as well as postgraduate course. Next paragraph. Upon receipt of such application, an inspection was conducted by the PCI and upon due satisfaction an approval was issued in the instant case. The approval of the PCI was received sometimes in the month of such and such. Based on approval, the college appellant has considered about 20 students eligible for undertaking postgraduate course called M.Pharm. That would, however, not by itself fulfill the requirement of section 12 of the Act of 1948. Subsection 2 specified that a separate process of, and this is important, a separate process of approval and permission involving the examining body the authority of examining body itself specified under the appendix to the Regulation 17 of the Pharmacy Education Regulation 2014. A plain reading of subsection 2 therefore confers the authority on the MACAUT, which is to conduct examination for the student enrolled with the appellant college and the issue degree and marks. The university also required to appoint examiners for the aforesaid purpose. It is therefore clear and explicit in terms of section 12 of the Act of 1948 that for the commencement of a lawful course in pharmacy, the PCI approval for both the appellant as well as examining body, namely MACAUT, are mandatory, which is the regime conceived under Act of 1948. Given at the large volume of deficiencies and the omission found by the examining body, the MACAUT duly supported by the learned advocate for the PCI, this court is of clear view that the appellant institution cannot be allowed to commence the informed course. The provision of section 13 of the Act 1948 may also be attracted in the facts in the case. This court, however, does not wish to make any conclusive pronouncement in this regard. Next page. Paragraph 25 is important, the observation. The court is of view that examining body's inspection is an additional check and balance over the above PCI initial inspection and approval. The opinion, views and deficiency found by the MACAUT cannot be ignored by the PCI given us the provision such and such. For the reasons stated here above, the court is view that the order dated 3rd January 2025 passed by the single bench cannot be faulted. But PCI alone is not the authority. Condition, future of the student is the paramount consideration. Examining authority is the state authority. They have every right to inspect, even after an order passed by the Honorable Calcutta High Court in a public interest litigation. It's the duty of the university to do continuous check. This is my submission on behalf of PCI.
And may I just only kindly takes up paragraph 4, 5C of this judgment. This was in regards to this college was running B Pharma course. They wanted to initiate another M Pharma course. No, point is not.
Let me hear the
Only may I just
respective authority.
yes, may I just rejoin one issue to Mr. Tiwari's. For running a college, to open a college, two factors are required.
Opening or running?
Opening and running both.
Both.
First, PCI gives the approval in respect of the course. That is the approval part. After that, they have formulated one SIF, standard inspection form. Following that, we also have to inform as per the law. We give affiliation in respect of the college, being the examining authority. Earlier, if one college under a trust applies, they get inspected by the PCI or on the basis of their submitted documents. PCI, they prescribe format, they fill up, PCI gives the approval, but the duty lies on us to inspect physically. We cannot.
Did you go for inspection this year?
Yes.
You went?
Yes.
When?
That is at the time of 2022-23, we find primarily we give consent to affiliation, subject to on the basis of their documents and their undertakings. Thereafter, we inspect. Earlier, what happened, my lord? We relied on the government officers because a limited numbers of officers. In this only 18 to 20, I have been instructed that only 18 to 20 officers were there, keeping aside this lady teachers from the government colleges, polytechnic colleges and employment exchange. Out of that, they were not expertised in pharmacy in all the matters. Whatever they physically verified, they keeping in parity with the SIF. They used to check, yes, these are the rooms, these are the available paraphernalia, equipments, all are there. And based on that, relying on that, we give them this affiliation. Now,
Tell me, they want the affiliation for this session, 25-26.
Yes.
When was the inspection conducted?
yes, may I come up? Yes, inspection. This is the SIF at page 44.
The date of last inspection, page 45, mentions 10th of
12 under this absolutely bottom, 12 November 2025.
Was this inspection actually conducted?
Yes, yes.
And
May I just come up and in detail, my lord, what the questions may come up from your ladyship. May I just point out one by one? Then what, my lord, usually we it is not possible for us to year verification earlier. But this order comes from the Honorable Chief Justice pursuant to a appeal matter that several colleges throughout the West Bengal, they are named only 4 and 5, that they are running illegal manner, not following that. Then comes this order. But along with those 6 or 7 colleges, Honorable Court directed to consider to inspect all over West Bengal. So we started. It started from March 2025 till December. Now during this inspection, the points, the defects we have, the deficiencies that detected by the inspectors.
where is the inspection report?
Inspection report, this is the, as per the SIF, this is the preliminary report. It has 2 parts, open part and one confidential part. What makes this year, from this year we have to go for this confidential part, because during the inspection, well, 2 sectors in educations. Nowadays, one I cannot name, it will be a huge agitation against me. It will be created.
Before the court?
No, now this one, that part, my lord assume which one.
No,
Another one is pharmacy. Another one is pharmacy. During inspection, we find there are huge in major deficiencies altered. The
Deficiencies altered means?
deficiencies and the arrangement has been altered, since the computers, the other vital paraphernalia, they have sold out. Not this one. I'm stating in general. We found that college is not at all running, no students, but they are getting renewal. They arrange for the examination somehow. These home centers, yes. No, I'm not saying instead of. I'm coming with your college. So these are the main difficulties, but the officers, the inspectors, my lord, were hugely pressurized, even this college also. Now this point is,
To
yes,
fill up.
to not to disclose the proper deficiencies and all. So they openly, as per their demand or whatever, under pressure, whatever possible for them.
File opposition.
Yes. Now,
Please come.
if your lordship pleases to once just have a look of the confidential report, what they say. The last one is, because they cannot disclose the. Very sorry. No, this cannot, my lord. I cannot submit this confidential to them.
I am not telling you to submit anything.
My lord, this is the inspector lastly says, I'm not going on to the extreme last page. We, the inspection team, would like to state that the inspection report previously submitted through the portal should be treated as null and void, as several entries were made under pressure.
Alright.
We also
I don't want to say anything.
Yes.
Whatever you've got.
Now I will disclose the entire
Alright.
stand, my lord, by one affidavit.
Only one
The-
thing, let them clarify, because they have denied the affiliation for 25-26.
Yes.
The students of 24-25 are undergoing the course merit. Let them clarify that not affect the students who are already undergoing the course of 24-25.
Why they are required to say? Because page 26 is impugned.
My lord.
The future one.
Yes.
Not touching the old ones. The refusal of affiliation for the 2-year diploma in pharmacy course for the academic session 2025-26 by the senior administrative officer, West Bengal State Council of Technical and Vocational Education and Skill Development, is impugned in the instant writ petition. Stop. The impugned rejection mentions that there are major deficiencies / disputes in the infrastructural and other facilities required to conduct the course. Stop. Details of the deficiencies are mentioned in the impugned order. Stop. Learned advocate for the petitioners contend that
Petition on one comment.
petitioner contends that that with the same infrastructural facility, affiliation was granted both by the Pharmacy Council of India and the state authority for conducting the course since 2022 onwards. Stop. All on a sudden, in the year 2026, after filing of the inspection report, affiliation ought not to be refused. Stop. The same will pose a problem for the students who intend to undergo the subject course. Stop. Prayer has been made to direct the authority to permit the college to take admission for the session 2025-26. Stop. Learned advocate representing the Pharmacy Council of India submits that the college ought to follow all the rules and the norms required for running the course. Stop. The state authority is the competent authority to physically check and verify whether all the infrastructural facilities are in place or not. Stop. Learned advocate representing the state authority submits upon instruction that there are several deficiencies which are required to be cured by the college for the purpose of obtaining affiliation for the current academic session. Stop. The application form which is annexed to the writ petition contains several remarks which have been obtained under pressure by the college. Stop. The authority intends to file an affidavit disclosing all facts and figures. Stop. Upon hearing the submission made on behalf of the parties and on perusal of the materials on record, it appears that the affiliating body has detected several deficiencies for which the affiliation for the current session has been withheld. Stop. The court ought not to pass any order in favor of the college to run the course till the deficiencies are removed. Stop paragraph. As the affiliating body intends to disclose certain facts by way of affidavit, stop, accordingly, let an affidavit by the West Bengal State Council of Technical and Vocational Education and skill development be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. Service is taken on record. Take back both your judgments.
3 to 6 are same.
3 to 6.
4, 5, 6.
I can remember one judgment passed by this bench regarding possibly B.Ed courses,
In code 14, my lord, your lordship had passed, my lord.
not in 1424.
No, in code number 14, my lord, in 2024, your lordship had passed, my lord. We were applying for the universities, my lord.
But I distinctly remember when I was in code number 24, a similar matter was there and I refused to allow affiliation to take up because whatever is there in this judgment.
My matter only, Ranibara College of Education.
Yes. Maybe.
And DLED course, my lord.
DLED course. And I refused. You took up in
My lord, some other advocate on the bench.
maybe. Then has it been allowed or
No, can withdrawn the appeal, my lord. Subsequently withdrawn the appeal, my lord.
withdrew?
All
So that judgment
Each and every year it will be coming and it came, but
especially the mushrooming of
Yes.
illegal colleges.
we cannot control it.
After 2020, my lord, after 2020 there was a moratorium. After 2020 there is a mushroom going. All B.Ed college has been converted into pharmacy colleges now.
And the main issue is dual occupancy. Okay, in one building,
Because in private, my lord, the selection is going.
from one building, B.Ed, from front side, back side, pharmacy.
Even in some cases
And in
PCI,
the middle something else.
even in some cases PCI officers came to inspect. No, they couldn't found the college. Subsequently they were
Yes,
taken.
yes,
They were
yes.
thrown a PCI B.Ed college as a turned into PCI.
And
There are two boards.
No.
exactly, I remember these facts.
One may I just, in one instance, one case that came out, they shown Panchayat auditorium as their college.
Education
Then
sector.
see if your officers,
Now we are not taking strictly. After the pill, we cannot give any relaxation.
so you waited for the pill to come.
Not at all, not at all.
Could not take steps.
No, not that. We
The
just
court has to interfere in each and every matter to put you all in that
over
right
the year,
track.
now the duty each and every year.
আচ্ছা 4 নম্বর 5 নম্বর
More matters not similar, my lord. We had mentioned this. But my lord, for some reason the matters are not appearing. If it can be taken up tomorrow, my lord.
you want it to be done before this bench, but try some other end.
Consent আজকে নিয়ে But if your lordship takes up the matter on consent, same similar order may be passed, my lord.
Yes, yes, obviously similar order will be passed.
Matter, but one matter they will be surprised. My lord, if you lost
It's surprised. কালকে দিয়ে দিন. Let us all see what is the surprise.
That to in education sector, my
Give
lord.
the number.
Yes, sir. Number
Grateful, lordship.
Yes. 7. Seven will be passed over for the time being. It will be taken up. কখন আসবে file? এটা কি কালকে হয়েছে?
Eight ham for the petitioner.
Yes.
Item number 6, my lord. I and Anet GP appearing for the state. Item 6.
Item number 6.
6.
Appearance টা নিয়ে নিতে হবে 6.
Pending the affidavit of service. The matter in the year 1999, petitioner appointed as an
Who is there in it? Respondent?
For the board, man.
we have served all the respondents.
West Bengal Regional School Service Commission, Regional School Service Commission, Higher Secondary Council of Secondary Education. Board DI. Who is the answering respondent?
Answering respondent is 7.
7 DI. That means the state. Check up. Check up.
File the supplement
Supplementary.
and the approval service.
We will not do. I want to see the person over here.
Make it. Then not today. I can issue notice again by today.
Make a phone call. Bring your learned friend.
No, still.
I'm passing it over.
Yes.
Bring him.
It will take
3 to 6 might have been called on together, 3 to 6.
Yes.
There was a 6
देखो तो
9. Huh? 7 এসছে? হ্যাঁ ডেকে নিন 7 এ পিটিশনার কোথায় গেল? পিটিশনার 7 item 7.
Item 7, madam, led by Mr. Ujjwal Rai.
Huh? Hello.
My lord, in item number 7, my lord, this petitioner was transferred, being a general category person.
Day before yesterday, my lord, I got 1 day's time. I have.
What does it say? Give a copy to him.
Lord, it is not a formal transfer. It is only a stopgap arrangement. Kindly have a look to 2-3 paragraph and the people teachers ratio. My lord, kindly have a look to 3rd, 4th and 6th paragraph. And also the next page, my lord. I am giving the copy, my lord.
All right. Yes.
My lord, I have to take an exception to this because they are saying since it is a temporary arrangement, the roster does not apply, my lord. We need to check this up and come back with an exception.
My lord, kindly have a look to
Check up.
the
Whether
people,
the roster,
Check up
my lord,
now.
the only
people
thing-
teachers ratio,
my
my lord.
lord,
I have seen.
my lord, the only
I am
thing is that
And my lord, one more thing, my lord, one more thing. She is not alone. Two and another teachers also transferred. It is page number 22 of the writ petition, my lord. And
From same school to the.
no, she is coming from another school. Only the one more thing, my lord. Salary disbursing authority and
I have
service
seen
record.
service record remains the
Everything
same.
remains. It is stopgap arrangement.
But
Only
till somebody
only
regular
the
candidate is
dire
found,
need of
I got
my
it.
lord, the only
teachers,
thing
my
is,
lord. I am deeply obliged.
my lord, on 24th, the school has issued a release order in my favor.
Please join.
My
Court is not interfering. Please come.
I am deeply obliged.
The instruction forwarded by the Commissioner of School Education,
Yes, Commissioner.
signed on 25th of February 2026, handed over in court today by the learned advocate representing the state respondents, is taken on record. Stop. It appears therefrom that the placement order dated 29th of January 2026, impugned by the petitioner, is a mere temporary arrangement that has been made by the authority to utilize the service of the petitioner in Tapsia Junior in Netai, Netai, Netai High School, as there is dire need of a bioscience teacher, my lord, in the said school. Stop. The pupil teacher ratio in Tapsia Junior High School, which is the present place of posting of the petitioner, is 19:6, whereas the pupil teacher ratio in Netai High School is 303:4. Stop. The distance traversed by the petitioner from her residence to Tapsia Junior High School is 61.9 kilometers. Yes. Whereas the distance to the Netai High School from the petitioner's residence is 47.6 kilometers. Stop. The commissioner has specifically mentioned that the service condition of the petitioner, including the salary releasing authority and the service records of the petitioner, shall remain unchanged. I am deeply obliged. ঠিক আছে? Paragraph. As it appears that the place of that the petitioner has been placed in Netai High School as a mere stopgap arrangement in the interest of the students. Accordingly, the court is not inclined to interfere in the instant writ petition. Stop. It will be open for the The petitioner shall take steps in terms of the placement order dated 29th of January 2026. The writ petition stands disposed of.
One prayer. And if the stopgap arrangement is no longer required, she'll be reverted to her school manner. If that could be recorded, right?
No, nothing. Not at this stage. First you go and join.
Grateful, madam.
9.
Item number 8.
I am just now I got the brief, my lord. Please give me a time to collect the. Yes. Let me see. 8. What is your prayer?
Prayer, my lord, for transfer. What has happened, my lord, on the ground of medical experience. Now, in the year 1999, I am appointed as an assistant teacher.
Where is your application?
Application is at page 29 onwards. Several application I have made page 29 onwards. 26. And except P12. And I have attached all the medical.
Thing is, the application for transfer has to be in a prescribed format. Where is that?
General application I have made.
General application, there is nothing called general application. The petitioner seeks transfer on medical ground.
Yes.
Stop. On a perusal of the documents annexed to the writ petition, it appears that the petitioner is yet to make a formal application in the prescribed format seeking transfer. Paragraph. In view of the above, the instant writ petition stands disposed of with the observation that usual order jeta ache, make application, it will be considered. Disposed. Yes, yes, time is mentioned in the order.
I think 9 my lord, I am for the petitioner now. Petitioner's launch. Then you will also have only decided the issue, my lord. We are working as Shoika. Issue Kendra, my lord. Initially, my lord.
For the respondent, my lord. Yes, my lord. I have come.
Page 170. This is the order, my lord. Your lordship told me yesterday, gave me yesterday to annex this order, my lord. Page 170, my lord. Similar order, my lord, will be passed by your lordship. Only costed is required to be changed, my lord. Page 170, my lord.
Where is Mr. Jahan? Is he contesting the election?
No, my lord, he is engaged in court number 11.
Oh, he is coming to court?
Yes, yes, my lord.
170.
Page 170, my lord. This is the order, my lord, passed by your lordship.
Is there any deficit court fees to be paid here?
I have to pay the post fee, my lord, but I told my clerk, my lord, to pay, bring the printout, my lord, kindly fill.
Doesn't matter, there is a requirement of deficit court fee. How many petitioners?
90 petitioner, my lord. 90. 9090. Yes, my lord.
Alright.
That, my lord.
Alright, wait. Petitioners were initially serving as Shahayak, Shahik and Shishu Shikha, the exercise option. The benefit of para teacher. Same order 170, 171. শুধু এইটা চেঞ্জ হবে, অ্যাপিয়ারেন্সটা নিয়ে নেবেন। Alright, disposed.
I shall submit the, my lord, defensive, with the 15 minutes, my lord.
If it is reflected in the CIS,
No, I said submit, I said,
alright, please give.
আমি কে করে আছি অলরেডি লড়ছি
Matter was filed at one instance, appeals for the petition. Matter has
My lord, before my lord, senior starts, my lord, I'm praying for a very short passover, my lord. I'm led
On
by,
whose behalf?
my lord, I'm for the Jadavpur University. I'm led by Mr. Joydeep Kaur, my lord. He's on his legs. A very short passover, my lord.
only password.
Who is assisting Mr. Kaur?
My lord, Mr. Shomu Majumdar is also there, my lord. He, due to personal difficulty, is not in court, and my lord, I am the advocate on record.
Can he start and Mr. Kaur will join?
My lord, as my lord pleases, my lord. My lord, he is on his legs, my lord, as his clerk has informed me.
We will,
Wait. Passover?
I do not say anything, I leave it to the court.
Alright, I'm
whenever he
passing
comes-
the time back. Not whenever he comes. At least, let me see how much I can proceed. In that case, 1 o'clock or some.
There's a matter fixed, while Mr. Kaur is leading me, Nagapur. So,
Passover.
Tomorrow in that case?
No. But an application, it can be taken up at 2 PM today,
115, 110?
1:15.
My lord, tomorrow also, my lord, fairly at the top, if my lord takes,
Mr. Kaur is not available tomorrow, I am indicating it to your lordship. I know it for sure, he is not
Alright,
there.
gotcha.
my lord, kindly grant.
Keep an eye.
My lord.
Keep an eye when the matter is taken up. Yes. Call 12.
I am paying for a short passover.
I am what the state respondent.
Chaturvedi, my lord, Mr. PG Chaturvedi, my lord, please engage another court, my lord, can I beg to appear for 10 minutes, my lord. 10 minutes, my lord, pass over, my lord. It 1 PM, my lord.
Are you the on record?
Yes, my lord.
Just tell me what the matter is.
And the assistant headmaster.
Yes.
Regarding selection of assistant headmaster, selection was completed and thereafter panel was, one man panel was submitted. One of the contesting candidate, two candidate raised an objection. I have not withdrawn the application, so I was want to contest, but only compelled by some unauthorized person has the compelled to withdraw my application. Did I hold an inquiry?
Is it for constitution of the managing committee?
No, assistant headmaster. Assistant headmaster. So, I am for the DI. DI hold an inquiry. After inquiry, the panel.
You have a report?
Yes,
Please give.
hold an inquiry and
No, don't make submission, please give.
after inquiry, panel has been cancelled. Directed the HY to proceed in accordance with law, step by step according to the for selection to the headmaster, assistant headmaster. This is the position.
We have applied for that post. We are forced to withdraw by this
Yes.
petitioner.
All right.
Next page,
Yes, only one thing.
Next page.
Your worship kindly permits me.
Next page, last paragraph.
Let the petitioner places.
Alex, this matter, my lord, without wasting my lord's valuable time.
Ah.
My lord, I have so many documents to brought in into record. My lord, kindly have a leave, my lord, to file a report, my lord, in the form of an affidavit. Because the people, the private respondents, my lord, who have committed fraud with the court, he is attending the school. At the same time, he is sitting in the practical examination, Tamil Nadu. Well, this is very, very important. A inquiry is proceeded with against him as per the order of the board. My lord, kindly have a chance, my lord, so that I can file a report, my lord.
All right.
My lord, kindly
Let-
consider it. But my unnecessary sir want to enjoy the fruit my lord alone.
Yes, what is my
We
interest?
want that the
I-
superman panel would be up.
Let
We are
the
the contesting.
My lord,
let
I
the petitioner come. Pass over. Pass over.
Fine.
Keep an eye. I cannot say when so many matters are passed over.
Conclude.
The 14/9/2010, Millard, we had been working in various categories, Millard, under different departments of government of West Bengal. 2016, Millard, first SLST, we participated, we became successful, appointments given, Millard, but ultimately, Millard, we made a catastrophic end, Millard, and ultimately 3/4/2025, Millard, all appointments to cancelled. Now, Millard, the commission, Millard, on 20th, 30th August 2025, Millard had published, Millard, a list of 20 candidates, Millard, wherein, Millard, my clients' names were included. We thrown challenge, Millard, so far the list is concerned, it became unsuccessful challenge. My lord was kind enough to dismiss the petition since the list dated 30th August 25 was not a subject matter of challenge, but while dictating the order, Millard, from the YouTube, it appears, Millard, that your lordship ordered the liberty to grant, Millard, that has not been gone down, Millard, in the order sheet. Be that as it may, we filed a review application. Right? That is also pending. Thereafter, Millard, a final list has been published, elaborating and elucidating, Millard, why we became a tainted candidates. It says OMR mismatch. If one goes through the, Millard, the judgment of the division bench, page 363, Roman clause 4, and read with, Millard, paragraph, Millard, 47 and 23, Millard, the OMR mismatch, Millard, this category, Millard, does not come within the tainted candidates. So, Millard, we at the, Millard, we want to repatriate. We filed an application before the, Millard, the authority in terms of the Supreme Court judgment, and, Millard, this particular aspersion, Millard, it's a kind of insinuation or affront, Millard, to us, and we are not, Millard, since we had, Millard.
All right. Yesterday, similar matter was taken up on this list.
So this is
Dismissed.
It has been dismissed.
No, but this is not the point, possibly, Millard.
Same point. Absolute same issue.
OMR mismatch, Millard, kindly sees paragraph 20, paragraph 23 of the judgment.
The order possibly is not in the server as yet because
I can
yet to
unfortunately my instructing people are not here. To 21776 of 2025, Dibyendu Mondal, dated 28th October 2025.
oh, that's long back. Yesterday possibly.
Yesterday also there was another one matter, I was not there. 41 was perhaps the item. Oh, very, very well. This is
So that one, whatever you.
I'm just reading it. Petitioner is agreed by incorporation of his name in the list containing names of tainted candidates, which was published by memo dated 30th of upload করেছেন?
Yes, it's there in the screen.
Yes. Featuring names of 180. According to the petitioner, he should not be treated as tainted. The issue is no longer resting. The court has decided the issue by judgment dated this. By Shampa Ghosh, judgment dated this. Was assailed before the division bench and the judgment of this court was not interfered with. Learned advocate representing the commission has placed the order dated 12th September
passed by the Honorable Supreme Court in Bikash Patro in the aforesaid special leave petition judgment dated 2nd September was questioned and special leave petition was dismissed by the Honorable in view of this court finds no merit.
I do not know, my lord, the facts of the case, my lord.
This is one. There are other orders also passed by your lord. That order, I'm just giving your lord. Shampag Ghosh is also different.
Justice Bhattacharya's order, Shogata Bhattacharya, his lordship.
I can remember yesterday. I'll keep it next week.
Very good.
Second, let it come.
Second, I have resolution.
There is the combined list will come. If there is a resolution, the matter will not be taken away. It will be taken away the next day. What is the problem? Let it remain in the list of the second. Combined list. Second, let it remain. Whether you all are there or not, the matter will remain in the list. Second, list.
Resolution থাকলে জজ সাহেব নেন
না অল্পটা কি
এই জাজমেন্টটা দেন আমাকে দৃষ্টিভঙ্গি দেন জাজমেন্টটা
14 the issue is already decided by the take to appear for the state 14th.
SSC matter.
No, SSC matter. The issue is already decided by the larger bench of this honorable court, that is higher pay scale in respect
Higher pay scale.
in respect of physical education. And my lord,
Has your prayer been considered?
my lord, it has been considered and again rejected.
Let me see rejection. Oh, it's a detailed rejection.
Yes.
Then an affidavit has to be called for.
My case is, if your lordship just give me 2 minutes time. I'm not pressing my brief also even. My lord, my case is, my lord, this is a physical education, work education teacher. My case is, my lord, I passed out the master's degree in the year 2001. I joined in the year 2001. At the time of my joining, my lord, I was pursuing with this course. In the meantime, I joined. Thereafter, results were published. My lord, this is categorically settled issue, and issue is been decided. Single bench judgment. This is after considering the larger bench and Boishali Banerjee judgment. My lord, kindly see once. But this just nothing but same subject, physical education. Oh, the single bench ta dao. Ratna Saha. Where is it? Hey, Ratna Saha ta dao. But kindly see this. It is already decided considering the larger bench. But kindly come to paragraph 17. I think my learned friend of the state will not deny. But from 2001, my lord, the petitioners are suffering. In order to arrive at a logical conclusion of the instant writ petition, this court intends to have a look. May I just
Yes.
the intends to have a look at the relevant paragraphs of the reported decision of Boishali Banerjee Shukra, and the same is reproduced hereunder in verbatim. The case in hand is, however, having a salient feature. The appellant is a physical education teacher. I am also same. There is no honors degree taught by any of the universities in the state. Hence, there could be no such category in the school service commission in the concerned subject. We also do not find any such distinction being made in the physical education by the school service commission. Hence, all candidates who having appropriate qualification in physical education are considered in one category, that is pass category. If that be the position, their subsequent acquisition of postgraduate qualification cannot be equated with any other subject. In the instant case, the appellant undertook postgraduate study. She appeared in the postgraduate examination. Before the result could be published, she was selected and appointed in the post. In the case of Bhaskar Chakraborty, The identical situation happened, hence in our view, the appellant was entitled to the benefit of higher pay scale. But it is decided, my lord. Let us now examine the Act of 2005 to find out whether there is any hindrance in any of the...
Has the 2005 Act invoked in your case also?
According to me, my lord, 2005 Act is not required.
No, but then did they mention about the Control of Expenditure Act anywhere?
Yes, they have mentioned.
They have. All right, in that case, read. 2005 Act came in 5 and this was in 2001.
2001.
Have a retrospective effect.
Time and again now, my lord, physical education teachers are being. This one was allowed by the High Court, and my lord, I have heard, my lord, recently, my lord, it has been dismissed by the division bench. This was made in appeal. This Ratna Shaha, it has also already been dismissed by the division bench. This is the order. This is in upheld.
Yes.
Hence, may I just let us now examine the said Act of 2005 to find out whether there is any
2005 doesn't have any application.
Towards the end, my lord, your lordship would find the writ petition was allowed. কোন পেজটা বলছেন এটা 17 থেকে পড়বো না এটা না জাজমেন্ট দেখি but if someone, my lord, it is already settled by the larger bench তো even 2005 Control of Expenditure Act, there was a notification. My lord, I can show পারে larger bench টা দাও ওই এটা ওই গৌতম করণটা আরে larger bench টা নিয়ে আসুন in the larger bench also, it was settled that if someone is pursuing with one course and subsequently, my lord, he gets the degree. In the meantime, he is appointed. But this type of category will get higher pay scale for all subjects. This
is the ground of rejection over here.
The reason, my lord, kindly see, my lord.
First paragraph is facts.
My lord, kindly, may I just place, my lord? It's 56. Page 56. The Deputy Secretary of the, your lordship got it?
My lord, kindly see that page 56, my lord.
Page 56.
Page 56, the last paragraph onwards. From the Deputy Secretary of the School Education Department
has issued
an government order.
Please wait here.
Yes,
Lord. Secretary of the School Education Department had issued a government order number 538 ACS SP 13-2022 dated 22/4/22 regarding entitlement of postgraduate scale of pay in respect of physical education working under ROPA 90. Whereas the government order dated 22/4/20 inter alia as following. The undersigned is directed to invite a reference to his memo number 249 GA dated 1/4/2022 on the subject mentioned above and the state that the date of effect for granting the benefit of higher scale of pay, that is a postgraduate scale of pay for assistant teachers of physical education under ROPA 90, would be with effect from 1/1/86 or the date of improvement of qualification, whichever is later in terms of paragraph 16(3) of GO number 33 EDNB dated 7/3/90 as amended by GO number 401 EDN dated 10/9/91 and 216 EDNB dated 13/5/92 and not from 22/1/93 as stated in this department's memo number 795 EDN dated 22/11/93. This issues in terms of decision given by the Finance Department and in these departments file bearing number ACS SP 10916 on 6/5/2018, which was communicated earlier to CAC WB Vide these departments memo number such and such, and that after no such order has been issued from the competent authority to accord the higher scale of this group of teachers subsequently acquired NPA degree in work education, physical education group. Well, how did they pass this line, my lord? I cannot understand. that after that no such order has been issued from the competent authority to higher pay of this group of teachers subsequently accord MPA degree in work education, physical education group. But several orders are there, even government orders, court orders are there. Hence, in light of the aforesaid provision, existing rule, government order, all of the above observations made by the Honorable Apex
Yes,
Court.
what is your stand?
My lord, I cannot deny, my lord, there is a covered judgment. That I cannot deny. My lord, he is saying, my lord, no such order has been issued from the competent authority. Who is the competent authority? That also has not been mentioned. So since there is a covered judgment, my lord, I cannot stand in the way of justice. I leave it to your lordship.
Thank you so much for being so fair. Please come.
Lord, item 37 is also same. Madam.
Please wait.
Physical education.
The order passed by the District Inspector of Schools, Secondary Education, Kolkata, dated 12th June 2025. Rejecting the petitioner's prayer for grant of higher scale of pay is impugned in the instant writ petition. Yep. Paragraph. The petitioner passed the Bachelor of Physical Education in the year 1999 and completed her Master degree in Physical Education in the year 2001. Stop. A letter of recommendation was issued in her favor for appointment. An appointment letter was issued in her favor on 21st April 2001. The result of the master degree course in physical education was published on 21st of September 2001. Stop. In September 2004, the petitioner applied for grant of higher scale of pay on acquiring the master degree. Stop. The prayer of the petitioner stood rejected. Stop. The rejection was challenged by the petitioner in WPA 6547 of 2006. Stop. On 21st of December 2012, the said writ petition stood disposed of by the court. Where is that order?
প্রথম dismissal order. প্রথমটা যেটা
Oh, first order.
Page 30.
যেটা কনসিডার করতে বললো
না consider না
21st of December. ঠিক আছে? By the
কনসিডার করতে বললো
that is at page 35 that the
by the said
65
by কি বললাম
6546 and I also got one more 6547
by the court
Yes,
by passing judgment setting aside the order of the setting aside the impugned order and directing the DI to grant higher scale of pay. Uh-huh. 6546.
My lord, 6546, my lord, is the writ petition of the petitioner, of this petitioner.
6546 which
Yes.
page?
petitioner this is a
And
47
and the order in 6546 had been passed on the basis of the order in 6547
47
in the case of Amitabh Manna. But the similar issue had been decided.
All right.
page 47 is my order
Okay.
বলতে হবে তো ঠিক মতো ফ্যাক্ট গুলো
for 6 of 2006. Now, disposed of, judgment of enough to disposed of, directing the district inspector of schools to take a decision on the prayer of the petitioner seeking higher scale of pay for acquiring master degree in line with the judgment delivered by the court on 21st December 2012 in WP 6547W of 2006 within bracket Amrita Manna versus State of West Bengal and others. Challenging the judgment passed in the matter of Amrita Manna within bracket Supra, an appeal.
That is page 51, Milord. No,
Challenging the order passed by the court in respect of the petitioner, an appeal was preferred. Which stood disposed of by the appeal number 10 to MAT 688 of 2014, page 51, which stood disposed of by the Honorable Division Bench on 21st of February 2025. Holding that the issue has already been decided by the three-judge bench of the court in the case of Utpal Kanti Koron and others versus State of West Bengal and others. Reported in 2024 SCC Online Cal 1274. Stop. In the impugned order, the District Inspector of Schools considered the case of the petitioner and rejected the same by holding that no order has been issued by the competent authority to accord higher scale of pay to those group of teachers subsequently acquiring MPed degree in work education and physical education group. Stop. Learned advocate for the petitioner submits that as the issue has been conclusively decided by the three-judge bench of this court, the DI ought to have acted in terms of the said decision and not wait for any order to be passed by the competent authority in this regard. Stop. The learned advocate for the petitioner reiterates the relevant provisions in the judgment of Utpal Kanti Koron within brackets Supra in support of the submission that the petitioner would be entitled to the higher scale of pay. Stop. Reliance has also been placed on the order dated 21st of January 2025 passed by the court in WPA 18602 of 2018 in the matter of Ratna Shaha versus State of West Bengal and others, wherein the court in a similar issue was pleased to direct the respondent authority to grant postgraduate scale of pay with effect from the date of her appointment by taking into consideration the master degree in physical education. Stop paragraph. Prayer has been made to set aside the impugned order and to direct the authority to grant higher scale of pay to the petitioner. Paragraph. Learned advocate representing the state respondents very fairly submits before the court that the issue in question has been decided by the three-judge bench in the matter of Utpal Kanti Karan. Stop paragraph. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials on record, it appears that the issue is already covered and decided in the matter of Utpal Kanti Karan. Stop. The petitioner joined the master degree course prior to getting her appointment. Stop. Her final examination was conducted after she got the job. Stop. In such a situation, the candidate would be entitled to receive higher scale of pay upon enhancement of her educational qualification. Stop. The district inspector of schools misdirected himself by waiting for order from the competent authority for according higher scale of pay. Stop. The DI ought to have taken steps in terms of the law laid down by the court and not wait for any further order to be issued by the competent authority. Stop. Once an issue has been decided and the matter is referred back to the authority for taking a decision relying on the said judgment, then the authority ought to have taken steps in terms of the law laid down in the said judgment. Stop. The reason provided by the district inspector of schools to reject the prayer of the petitioner does not appear to be proper. Stop. Next, in view of the above, the impugned order stands set aside. Stop. The DI is directed to recalculate the salary of the petitioner after providing her the higher scale of pay, taking into consideration her master degree qualification in physical education. Stop. Steps shall be taken by the district inspector of schools in this regard at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. All arrear payment shall be cleared positively within a period of 6 months from the date of communication of this order. Stop. The higher pay scale shall be provided on and from the date of declaration of the result. When was the result declared?
The result was declared on September
2021.
Yes, ma'am. No, not 20.
Yes, 21st.
This is master base 21st of September 2001. 2001.
Date of declaration of the result. Disposed.
Ungrateful.
That item 15, well, kindly remember, well, yesterday, well, item number 7, when I moved it regarding Balika Shiksha Shodhan. Well, your lordship has seen, well, two other petitions are there. These are two petitions, 15 and 16. So, well, item number 7 order will govern this.
Yesterday's item 7.
Yes. Nomita Roy.
Is your learned friend aware?
No. He was not there.
Item 7.
কালকে জজ সাহেব যে অর্ডারটা দিয়েছেন 7 এ ওই একই অর্ডার হবে। WPA নাম্বারটা বলো। 28794 WPA। পলাশ নিয়েছিলে? পলাশ নিয়েছিল।
28794.
Yes, my lord's court officer was there who has taken the dictation. কি বলছো উল্টো পাল্টা দেখো ঠিক স্যার।
Item number?
Item number 7
কালকে লিস্টে
আমি আজকেও দেখলাম
এই তো yes 28794 yes
কি ছিল দেখি একটু কি
26
upon the authority to revert with instructions.
Yes.
All right.
15 and 6
ওটা কবে রিটার্নেবল আছে দেখুন
15 16 সেভ
ইনস্ট্রাকশন নিয়ে আসতে হবে।
হ্যাঁ ডিআই কলকাতা
18th of March this matter is also made returnable along with that matter. All right. ঠিক আছে same order. Next one will also be the same.
yes 6
All right.
but this is my affidavit.
All right.
My lord, item 17, my lord.
16
no 16.
এই পড়ে গেল
grateful
The matters related to the higher scale of pay, my lords.
considered or not considered?
Consider, my lords.
Consider
Where is your prayer?
application is pending in lordship.
Page 55, my lords.
At 55, lordship may direct the concerned authority to dispose of the application in terms of the
This order is there, my lords. Consider this matter. DI, my lord, should be Purva Vada.
অপূর্ব এটা হার আছে এটা হিজ হবে এই বলে সেম অর্ডার করে দেবেন ডিসপোজড
Kindly takes it up.
হয়
18. আমি রেডি বলো কমিশন আছে
tomorrow not today
What to do?
But the contention of the petitioners in this matter, that pursuant to the final judgment dated 22nd April 2024 passed in that batch matter, as affirmed by the final judgment dated 3rd April 2025 by the Honorable Supreme Court.
Ready? No? Is it an SSC matter?
This is SSC but not in connection with the second SLST because my contention.
Alright, who is appearing for the commission? Did you serve?
Yes, Manad. I have served. I have sent the notice pursuant to your lordship's note after upgradation.
Who is appearing? Any idea?
Kumar Pathak. Mr. Dholis was state for commission. Ranodip Kumar Pathak was state. To the SSC, to the.
Who is the learned advocate you say for the commission?
Received by Ranodip Kumar Pathak, advocate.
On whose behalf?
My junior, Ravindra Kumar Pathak.
Alright, that is for the state. What about the commission?
To be so. Yesterday also Mr. Patra was informed by my.
Is Mr. Patra appearing?
My lord.
If yes, call him. Make a phone call. He'll be here. Yes. What is your prayer?
My prayer, Malad, is that Malad, our case is that Malad, the selection process, which was directed to be conducted by the final judgment dated 22nd April 2024, as confirmed or affirmed by the Malad final judgment of 3rd April of the Honorable Supreme Court, has yet not been.
Has not been initiated. You will be there.
No.
This is regarding the 9-10.
This is regarding the first SLST. Malad, if your lordship allow me, Malad, I'll draw your lordship's kind attention of the conclusive portion of the Supreme Court judgment and the Honorable Division Bench.
Yes, certainly.
Yes, ma'am.
This is the teaching staff.
Teaching staff.
9-10. You say the recruitment, fresh recruitment has not been started.
Yes, recruitment, but the exact direction under 363 Roman 11 was SSC shall undertake a fresh selection process for the declared vacancies in respect of the selection process. The selection process first SLST 2016 was under consideration before the Honorable Division Bench, and that will be clear from the first paragraph of the Honorable Division Bench. What was the consideration? Now, that order final judgment has been confirmed, and under paragraph 51 of the final judgment of the third made clear that direction of the Honorable Division Bench is affirmed with certain modified directions from paragraph 45 to 50. From paragraph 45 to 50, all are regarding eligibility, relaxation, but no other further direction for conducting selection process in any other manner has been issued by the Honorable Supreme Court. So the review is marked. Then the direction of upon the SSC to conduct the selection process, which was under consideration for the division. But first SLST was initiated.
You'll be there. Just listen to what he says. Yes.
First SLST was initiated by the notification dated September 2016. The Honorable Division Bench under 363 Roman paragraph 1-2 made it clear that the appointments made out of the selection process has been cancelled. With the direction under paragraph Roman 11 to conduct a fresh selection of the post advertised in respect of these selection process. But this selection process which was under consideration was for the teaching staff past SLST 2016 and the for non-teaching hard LLST 2016. What they have done, but they have issued notification dated 30th May 2025 for conducting second SLST subject to pendency of the review petition. That is on the first page of the notification. In the notification, they have disclosed 32,000, more than 32,000 posts. In 2016, the number of vacancies were about 70,000. Also from the notification. That might have been increased one at 100 or 500 because that was tentative. The vacancy till the date of the interview could be also taken into consideration. So there is no selection process for conducting at first the 2016 selection. Why I am taking this one into losses, allow me I will draw certain paragraphs from the Honorable Supreme Court.
But then, you were aware that on 30th of May, a recruitment notice was published, right? For appointment in 9-10 and 11-12.
2011.
You did not challenge that?
No. I am not even till now. I am not raising any question regarding their new selection process second SSC. The SSC affirmed an affidavit before your lordship that this is the new selection process.
Yes.
That affidavit has been submitted before lordship. So, the new selection process on the new subsequent selection process on the subsequent recruitment rules having criteria, anybody can
apply.
Yeah.
Have you applied?
I have applied.
And you are unsuccessful.
No. They are not, somebody are successful, somebody are not.
All right.
But the fact remains, we have appeared without giving a right to appear in the selection process that's directed by the Honorable Division and affirmed by the Honorable. See that? So, from their notification, the notification of first SLST till date, neither by any administrative order nor by any judicial order has been cancelled. But after cancelling appointments is the final, more or less final result of the selection process because the settled principle of law that selection process starts with the notification and ends by appointment. So those appointments have been cancelled, but there are certain other the notification, application, consideration of preliminary consideration of the candidature, those have not been disturbed. I will show from on the face of the judgment of the division bench, and I will show from the order of the Honorable Supreme Court. The Supreme Court are direct just upon the direction of the division bench. And the modified direction from paragraph 40.
No, that is separate. So, is it your contention that the selection process that is going on now?
Yes.
Now, second SLST and the selection which stood cancelled, the first one, two selections will go on parallelly.
They have the right to conduct any subsequent selection process. I cannot oppose. They conducted according to their part, they have done. But the obligation created by the final judgment of 22nd April, they cannot oppose. That is my point. The obligation created upon the SSC. If the SSC misread the judgment and ordered meaning of the judgment and order, for that, my lord, no other can be supported. But I showed your lordship that this selection process to the second SLST is absolutely different. Number of vacancies is different, and the particular direction for conducting the selection process by the SSC at paragraph 11,363 paragraph of the division judgment.
All right, Mr. Bandyopadhyay, Mr. Bhattacharya, it will be your case only.
Yes.
No, let him serve a copy on Mr. Singh,
Because he challenges this and says that you have to conduct separate. Whatever you heard, the court has also heard the same thing.
Mr. Dev should serve it on Mr. Singh. Will come back on next week. Not on second.
These matters
are different.
Vacancies are different.
Either earlier vacancies has been considered or not, that also to be taken into account.
The summon substance is that 16 rules ought to have been followed instead of the 25 rules for conducting the selection.
Is also examining in other matters.
This, I see it is in the same line. Absolutely in the same line.
In that event, your lordship will tag it along with those matters. If it not talking about anything else. Only I have to disclose the fact. Only the notification rule.
Everybody is doing the same thing. It is the notification and the rules. No, same thing. There is same thing. The submission that you made that the 2016 and 2025 cannot merge together. The same submission is there in other matters also. It is the same submission. You may not. You may not, but I can see it. And the commission's councils are there. They know it. All right, please come.
In which order? Which rule they have?
The petitioners.
Rahul get a copy. Rahul.
Yeah, check text.
Now you have
Participated in first SLST 2016. Their appointment stood set aside by the court. Stop. They have participated in the second recruitment, second SLST conducted by the commission. Stop. Paragraph. They allege that the commission failed to discharge their obligation in conducting selection in terms of the judgment passed by the division bench of this court on 22nd of April 2024, affirmed by the Honorable Supreme Court on 3rd of April 2025 in the matter of Boishaki Bhattacharya. Stop. Paragraph. None represents the commission. Stop. Let a copy of the writ petition be served upon the commission. Stop. Released for further consideration on. Can you remember when are those matters fixed? On staggered dates they are fixed. Some 16th.
Fixed today.
Lubana is there in the list.
Yes. So Lubana, along with Lubana. There the rules are on everything is under challenge.
Do one thing on 16th. Go through it. Whatever is there. Service is taken on record. Just wait. Let him take some rest. Yes, call the next one.
Rahul ke pathi dao na, bolchi to finish.
Number 20.
Let me actually go. I appear for this papers.
This is it? All right.
I was appointed.
Tell me what is your prayer?
Prayer, my lord, the issue has been created by the page 40. EPPG. My lord, I had the B.Ed qualification and I was appointed as a B.Ed candidate. Then, my lord, at the instance of one gentleman, a case was filed and matter was came to the Honorable Court. Ultimately, it was held that, my lord, kindly look at page 30. If he undergoes, I was directed that as the first PhD degree has been cancelled, so he would appear again and he would obtain the PhD degree. I have obtained and continued, and I am going to return on 20. If he undergoes, this sentence is important, 30. If he undergoes training after discovery and accuracy, the appointment shall be regularized as a trained candidate. I was sitting as trained candidate, and I have got one in the scale of a normal scale, and I am going to return. The school forwarded all the pension papers. Now the EPPG has returned the papers asking for a clarification that what will be the date of his 10 candidate appointment. Kindly look at page 45. The school submitted all the papers. I have the honor to inform you that MD Belal Chaudhary Satan Sir was
his pension file has submitted on June 25 and objection raised from the DPPT and clarified as well. Whereas says that pursuant to the compliance of the order of the Honorable Court, whereas he completed undergoes B.Ed course and have regularized as a trained candidate from the day of appointment as an assistant teacher. He have been regularized as trained candidate, so no question of any overdrawn or irregular payment of salary. Kindly follow the orders of the Honorable High Court and fix his pension benefits. Now, my lord, but the DPPT has written the papers that you make further clarification. That is the issue. My lord, kindly, the story is given, my facts is from page 25 onwards, and it is a long order. And I was appointed, my lord, kindly see the first letter of approval, page 18.
What is your submission?
My lord, may I be permitted to submit page 25. This is a writ petition which was moved by the one petitioner, that is Torun Ghosh. My lord, Lani Raipur is Torun Ghosh. But that writ petition was, my lord, allowed. If you lordship kindly have a look to page 20. If you may be permitted.
Did Muhammad Belal Chowdhury, the petitioner, herein obtain any such order?
No. He did not obtain any such order.
This order that page 30 is being relied upon is in respect of which candidate?
Mr. Belal Chowdhury. He fraudulently by producing a document, he obtained the appointment.
Yes.
And that is why that particular gentleman filed the writ petition.
Please wait.
That he filed, that writ petition was filed.
Yes.
Dear Malad, Honorable Justice Kollanjyoti Sengupta was pleased to pass an order, maybe 2-3 page, Malad, page 28. Having considered the respective contention of the learned counsel of the parties, I am of the view the petitioner cannot get any relief as paid for in the writ petition, as he had already filed 2 successive writ petition for the self-same relief. As his fate has been settled, Justice Kobi on 18 July 2000, when his lordship has been pleased to observe that the writ application has been moved earlier on occasion, self-same cause of it. In view of the under rule such and such, that is civil rule. Next page, lordship kindly come to page 29. I am just reading from the middle portion, the cause of action. Lordships kindly have a look to the page 29, internal page 5. The cause of action shall remain same. An action is taken of the court to get relief on cause of action. If relief is barred, the petitioner cannot be allowed to take further recourse on the ground of fresh materials. As such, I am unable to grant my relief to the petitioner. The next question remains, lordships kindly noted. The next question remains whether at the instance of the petitioner any order should be passed taking note of the subsequent event. I think it should be become if there be any case of fraud. Well, the same must be set right. Under the circumstances, I direct the district inspector of school concerned to take note of the notification such and such and to make an inquiry in this matter. Lordships kindly next page, I am reading the entire thing. Annexed to the page 39 of the writ petition and to make an entry in the matter with the university concerned upon making inquiry if it is found that B.Ed examination was subsequently cancelled by the aforesaid notification, then the district inspector schools shall ask the school authorities to advise the respondent number 6 to that is the writ petitioner hearing, to undergo for a fresh B.Ed training. However, in the event he does not undergo for such training, then the appointment of the respondent number 6 petitioner hearing obviously shall be cancelled and withdrawn. If he undergoes training after discovery as aforesaid, the appointment shall be regularized as a trained candidate. Now, thereafter, one appeal was prepared before the Honorable Court. Next page, page 31. There, the division bench, affirmed the order passed by the learned single judge. Page 35. The court therefore directs the district inspector school to make a final inquiry on the basis of this order, and even after such inquiry, if the silence of the vice chancellor continues, in that case, the district inspector schools and the school authority shall act in terms of the directions by the learned single judge in its order under appeal and cause of action on materials which are available on record. Such inquiry is to be conducted by the inspector school should be concluded within 4 weeks from the date of communication of the order. With the consent of the parties, we therefore the appeal is on the list, and that is what that was disposed of. Lordships can come to next page 37. This is a order passed by the district inspector schools, addressed to the teacher in charge, secretary, the concerned school. In terms of the order of the Honorable High Court stated above, a letter was communicated BN Mondal University via such and such office memo dated 27th March 2006. In the reply, the BN Mondal University by the letter dated 26 April 2006 had stated that the quotation of RABEd College of Education was not recognized by the government of Bihar, Bihar NCTE Act 1993 and Bihar Teachers Training College Act 1982. In the said letter, it was clearly declared that the result of the Mr. Belal Chaudhary, the writ petition hearing, is also cancelled. Hence, as per direction of the Honorable High Court Calcutta, Belal Chaudhary will have to achieve fresh BA training in the session of 2026 and 2027. Now, 2006 and 7.
Then I have
Then page 38. This is 2006-7, 2007 he obtained the BA degree. So now since he has suppressed the entire fact of that application, that the certificate which he obtained earlier, that is not valid, and subsequently after that he obtained qualification 2007. So from that date he is entitled to get the benefit of scale of it. That is why the Pensioner Authority Finance Department, this letter, that is page 39, it has been issued. So his that qualification should be calculated from the date of achievement of that particular degree, qualification, B.Ed degree.
No, but my lord, I am stressing on the word. If he undergoes the training after discovery is apostate, the appointment shall be regularized as a trained candidate. I am all alone, my lord, I was appointed as a trained candidate. Subsequently, dispute cropped up, and my lord, that was clarified in details how it happened. Naturally, now this is the crux of the problem. The DPPG also say
the fact remains that he obtained that particular bachelor's degree of education, that is 2007. Before that, he was not trained candidate.
But I was appointed as a trained candidate.
But then your certificate stood cancelled. How can you get the benefits?
But my lord, discovery, my lord Justice Kolyanjoti clarified that if he undergoes a training, after discovery as report says, the appointment shall be treated as a trained candidate, regularized as a trained candidate.
Yes.
Whether it is from the very beginning or
it cannot be. If you do not have the training in 2004.
Training I had.
Sorry, sir. Please come. The petitioner is aggrieved by the.
So you will not say kindly. This is the 7 or from the
is aggrieved by the communication made by the DPPG on 12th December 2025, seeking clarification from the Pension Sanctioning Authority as regards the date from which the petitioner shall be treated as a trained candidate. Stop paragraph. The petitioner refers to the order dated 5th May 2004, passed in WP 9863W of 2001. Within brackets,
filed by one MD Jalaluddin Ahmed.
Muhammad Jalaluddin Ahmed versus the state of West Bengal and others, wherein the petitioner was impleaded as respondent number 6. In the said matter, the court directed that if the petitioner herein undergoes training, the appointment, his appointment shall be regularized as a trained candidate. The training, the training was obtained by the petitioner from B.N.Mandal University in Bihar. Stop. As the said university was not recognized, comma, the B.Ed degree stood cancelled. Stop. The petitioner obtained further B.Ed degree from the University of North Bengal and certificate to that effect was issued by the University of North Bengal on 11th March 2008. Stop. Learned advocate for the petitioner contends that the benefit of training, benefit of the B.Ed degree ought to be given on and from the date of his appointment. Stop. The court cannot accept such contention. আচ্ছা, from date of appointment একটু লিখে নিন তারপরে appointment in terms of the order passed by the court on 5th May 2004. Stop. The court cannot accept such contention. Stop. The B.Ed degree relying on which the petitioner seeks financial benefit stood cancelled, and the petitioner had to obtain fresh degree in March 2008. Stop. The court, while passing order on 5th of May 2004, was could not have apprehended a situation where the B.Ed degree relied upon by the petitioner stood cancelled. Stop. The petitioner cannot be granted any benefit relying on a cancelled educational qualification. Stop. After obtaining further B.Ed from the University of North Bengal, the petitioner would be entitled to receive the financial benefit. Stop. Next, in view of the above, the instant writ petition stands disposed of by holding that the petitioner would be entitled to receive financial benefit of the B.Ed degree on and from 11th March 2008, comma, the date the certificate, B.Ed certificate, was issued in favor of the petitioner. Writ petition disposed.
I was going to rely only
Service taken on record.
regular is a trained candidate. That was my lord our basis.
হ্যাঁ 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 একটা তো বাজেনি। এইটা একটা সময় ডাকবো বললাম না?
The affidavit service. This matter, my lord, pertains to my lord, the petitioners before your lordship are students of the Jadavpur University, my lord, who were issued show cause notices alleging ragging of a student. Jadavpur University. My lord, in that stage, my lord, challenging the so cause, because so cause itself is preconceived, my lord, it spells the punishment, and it is only the
stage, it is a stage before the imposition of the final punishment. These students, they didn't reply to the show cause, they came up before this honorable court. There are other students who replied to the show cause and they have been imposed with the punishment without considering. At that stage, the honorable court was hearing the matter. It went up to the stage for filing of written notes. Thereafter, there was a change of determination and the matter was not taken up thereafter, but before the other benches we tried our luck, the matter is still pending for hearing before court number, the other bench. In the meantime, many subsequent developments took place and we filed applications, my lord. The last
That's the interim relief that
yes,
you are
yes,
seeking.
today, my lord, we are praying for. There are 3 applicants before your lordship. Out of the 15 petitioners, these 3 persons, my lord, are current students. They are facing the difficulty. They are not being allowed to sit for their examinations. Now, my lord, the punishment which was spelled out in the show cause, my lord, was 1 semester debarment and to leave the hostel. Now, thereafter, my lord, the university has taken decision to not to allow these students to sit for their upcoming examinations. They are not issuing, they are not publishing their the results which in the examinations which they have already appeared. As a result, my lord, my lord, they are facing difficulty in they have come to know that they have passed, but the results are not given to them. Now they are unable to take. They are taking, the university is taking a decision that these students will not be treated as promoted to the next class, and the further examinations they will not be allowed to sit without there being any penal order against us, without we being implicated in the criminal matter.
But some proceeding is going on against you. Yes.
We came to your lordship's court at the show cause stage. The lordship's court intervened, to the extent not to give any replies. Rightly, wrongly, we are permitted to continue in the hostel. So this is that incident that the border took place. This is that. The matter is at the show cause stage. Now, during pendency, when they could not unnerve us and they had to allow us to participate in the college, university, its activities, its academic activities, everything, and also permit us to sit in a part of the hostel. What they did is, in the month of January 2025, without obtaining any deed from the court, with a part of the record here, they adopted a decision in the EC saying that barring these students, everyone would be issued the results and whatever. Now, today the position actually is, we are here 3 students are now immediately affected. Our results have not been published. We don't know the fate. All on a sudden, we have brought it to the notice of the regular bench. The regular bench, the matter was appearing under the heading hearing. There were number of applications. When the application was taken up, it was understood the applications will be heard along with the main petition. Now, rightly wrongly, suddenly, they have pasted something on the notice board saying that this number of students, which includes most of these petitioners, that their results shall not be. Some of them have also got jobs through campus. In fact, the petitioner number 1 is working somewhere, but his results has to be produced. Now, today he has left the hostel. He is no longer a part of the hostel. He is no longer a part of the university also. Now, these results being awaited, the examination is coming. What today, the immediate urgency is, the examination is coming on Monday next.
Second.
On second. Now, what I will be humbly beseeching your lordship, 3 of the students, 3 out of these 15, 3 candidates will not have their exams, which are commencing from Monday. Wholly without prejudice, results, nothing, for the present, will not be published, may they at least appear in the examination. Otherwise,
and
the order, if your lordship sees the main punishment proposed in the show cause is 1 year debarment, 6 months debarment. Highest penalty is
4 semesters.
4 semesters. Highest penalty. That too not for all.
Also, these three 1 semester.
These 3 1 semester.
1 semester is of 6 months.
6 months. Today, what is happening is
the 6 months period is over.
Long.
24 matter it is.
This is a 24 matter. Now, Milan, the matter was extensively heard by a coordinate bench. The matter travelled to the stage of filing written notes also. Thereafter, since the Milan, whatever, Milan, ultimately in the month of January 2025, they adopted a resolution, Milan, not to publish. Now, we brought it to the notice of the court. A separate writ petition was filed. When the separate writ petition was sought to be moved before the coordinate bench, Milan, again a plea was taken that the main matter is pending. So, Milan, both the matters today are now before the court. We have taken out appropriate applications, Milan, seeking intervention of the court.
Now show me your examination schedule.
Yes.
Examination schedule.
Were you in a position to fill up your application form? No. All right. Has the date?
Can 6 is a part of the records. Now, can 6 kindly?
Yes, can 6.
28.
28.
এটা পরে এসেছে যেটা আমি সাপ্লিমেন্টারি করেছি কালকে।
Can 6 is 28. Milord, কোথায় আছে দেখলাম?
এইটা পরে আগে ছিল।
Milord, this was previous.
এই যে
Start date and end date Milord kindly see. Now, Milord, yesterday
এটা আবার করেছে।
a fresh notice has been circulated, Milord, I'm seeking in a WhatsApp group, Milord, bioenergetics and bioprocess engineering classes test will be held on 2nd March 2026. I'm giving a copy to my learned senior friend.
So page 28, you are not relying upon.
28, Milord, was the
This has been postponed
to 2nd March.
I can see the academic calendar 25-26
Yes,
for the
yes.
second semester.
Yes.
And academic sessions.
May I request some of the petitioners are going now.
All right.
Just come. একটু বলো পুলিশকে বলো।
This must be ongoing. Last test 9th of February 26. That is over.
Then is 30th March.
Then is 30th.
Test 2.
Yes.
This 9th February 2026 has been postponed to 2nd March. That is my instruction.
Is this the postponement?
class monitor circulated in the WhatsApp.
Class monitor. Class monitor has circulated it in
WhatsApp.
And Milord, on merits, Milord, I definitely have some case, Milord.
But that will be in the main matter.
For the present, Milord, kindly protect us, Milord. Otherwise, we'll be absolutely, Milord, today the position factually is become Milord, extremely Milord, difficult for us. Some of us have withdrawn from the petition house.
Let me hear.
But
Give a copy of this.
I've got it. But please come to page 20.
Application.
Yes, this can number 6, which has been moved today.
Yes.
Look, this is the decision which was taken on 7th January 2025. Look, please come to paragraph B. The anti-ragging committee further held a threadbare discussion on the agenda, point number such and such. 15 students out of the total number of students accused of ragging, which happened on 9th August 2023 at the main hostel, Jadavpur University, and who have filed writ petitions, so and so, against Jadavpur University. The semester results will be withheld by the university until the final judgment from the court on the above mentioned writ petition is delivered. The rest of the accused students who did not go out to the court and have accepted the punishment of serving 1 semester's suspension, their semester results will be available to them. Now, Lord, this is the decision which is challenged in Can 5. That was moved. The court refused to pass any order. Court said, I will hear out the main writ petition. And the main writ petition is ready for hearing. We have filed our affidavit. This is the stage that we are. Now, Lord, what happened is that, Lord, an incident happened on
Tell me, is any examination going to
But
take
this
place?
examination will not affect them because Lord, they will be permitted to sit for the backlog. There will be no difficulty because once the main matter is heard, if the university is wrong in taking this action, then Lord, then everything will go. But if the university is right,
then Lord, they have to be suspended for a semester because under order of court they have been attending classes. They are in the final semester. They're in the final semester. If we allow them to sit in the exam and their results are published, then Lord, they go out of the college. We don't get a chance to not impose any punishment on them. Lord, the incident had happened on
2nd March 2026. If they are not permitted to appear, you will permit them to appear in the backlog.
There will be backlog again, Lord, backlog examination. Because some of these students, I can't say about these three, but some of these students, they have not cleared their backlog. So those backlog examinations, they will get a chance to sit. Your Lordship can record my statement and Lord, on that basis, the main matter can be heard out, Lord, by the bench.
But these marks, I am told, will not have a bearing on my ultimate performance, my academic score. They will not wholly without prejudice.
If the university is agreeable to conduct an examination to clear a backlog, interim order cannot be granted. I'm sorry, please come.
Kindly record his statements.
Yes. Provided you all do not have any other matter, because I have fixed up other matters also. I do not know whether the commission is there. The writ petition is ready for hearing and is being heard by the regular bench. The matter has been mentioned citing urgency. The urgency that is pleaded is that the university is going to conduct a class test on Monday, 2nd March 2026. The petitioner has the applicants in Can 6 of 2026.
But I'm told only one of them. Only one of them, Lord, will get affected. The 2nd March, the other two are not. Well, whatever.
The applicants have not been permitted to appear in the said class test. Prayer has been made to permit the applicants to participate in the class test without prejudice to their rights and contention in the main writ petition. Paragraph. Its senior counsel representing the university submits upon instruction that one of the three applicants may be affected if the said candidate is not permitted to appear in the class test scheduled on 2nd March 2026. It has, however, been submitted that all the candidates would be permitted to appear in the backlog in the examination to clear the backlog papers. The paragraph. The fate of the petitioners shall abide by the result of the writ petition, as the university has taken a stand to permit the candidates to clear their backlog papers subject to the final result of the writ petition, accordingly, there is no requirement of passing any interim order in this matter at this stage. It will be open for the petitioners to pray for hearing of the main writ petition before the regular bench. Supplementary affidavit filed on behalf of the applicants in court today be written with the records. The copy of the same has been served upon the learned advocate representing the university. Service is taken on record. Yes, call the next matter. Yes.
For the post of headmaster.
For the post of headmaster, assistant headmaster, the panel is dedicated for the selection. The time that first so far as the other candidates who applied, the one was eligible. He withdrew his candidature, and the two also withdrew their candidatures later. But the rules do not provide for a one-man panel also. But accordingly, the headmaster will not prepare the panel.
What is the prayer that you've made?
I come to that. Now, the headmaster will not take it to the TI, but the TI will not say that one of the candidates, the respondent number 6, has complained that he withdrew his candidature under duress. So you reselect. Not the headmaster will not make a clarification. This is at page 40. Not the DI says that I will not consider any clarification. If since I have already said that you undertake a fresh selection process, you undertake a fresh selection process. Both these decisions of the district inspector of schools, not other subject matter of challenge before my lord. Not kindly sees.
Now, the private respondent and the school intends to file an opposition. So let them file at least a report by way of affidavit.
It requires.
All right.
The allegation which my learned friend will draw.
Yes, I shall satisfy your lordship.
Why the school is so interested?
Approval of the
Because
panel.
the headmaster has defalcated the
Assistant headmaster.
You file an application.
Panel the one-man panel. ठीक है? The prayer of the petitioner is opposed by the private respondent and the state respondent. Stop. Paragraph. The respondents are directed to file report by way of affidavit disclosing their respective stand along with supporting documents within a period of 4 weeks. Reply, if any, not reply, exception, if any, may be prepared and circulated within a fortnight thereafter. Stop. List the matter on 13th of April 2026.
Mine can be kept on record.
On record. Do you have a copy with you?
Yeah, I have the copy.
All right, prepare your affidavit. Instruction forwarded by the DI, SC, Purva Bardhaman, dated 12th September 2025, be written with the record.
The report will be circulated.
Yes, circulated. Item number 10, medical, yes. 10. Any breakthrough?
But I have got an entire list of the SC categories which have all remained vacant after yesterday's admission. And I have also got the 2 seats of ophthalmology. One I have already shown yesterday, IQ, and one is Sri Ramakrishna Sanaka Hospital.
But in ophthalmology, the candidate
Yes,
is not.
now kindly see, and this I say, as an officer of the court, because I happen to appear in many matters for the respondent before lordship. The moment the respondent comes up with a concession, the petitioner's stance starts changing. Now, why I say this? Kindly see, they have not disclosed this in their writ petition. There is a representation written by their learned advocate to us, which we received on 19th February. Kindly see their complaint in the second page. अच्छा
उधरটা 18 ফেব্রুয়ারি
release action number I am
ওটা ভুল বল
देखो डेट 18 February होता P5 very well. I take that back. Anyway, they kindly see the allegation. Some of the seats she preferred are reproduced below for your ready reference. Both are ophthalmology. The result of the third round was declared and published on 16 February, and it is noticed that some candidates with lower ranks and much lower choices of the institution mentioned in paragraph 2 are given priority, whereas my client is not allotted any seat in the institution despite being eligible. The examples of such malpractice are reproduced below from result for your ready reference.
And both are ophthalmology courses.
No, they're showing some other page. Both are MS ophthalmology. So when they approach us, Their allegation is with regard to ophthalmology. The moment I bring IQCT ophthalmology, the stance changes.
My lord,
Because the state is not fighting the litigation, state is trying to help the petitioner. That is not occurring well with them. Anyway, my lord, but to assist the court, my lord, I have got a list, my lord, of all the seats of SC category so that no conversion is required.
Show one to the candidate also.
Yes, my lord, I am giving my copy, my lord. $255 na kina.
Pediatrics is not here.
my lord, I am equipped with a judgment of Supreme Court where my lord Supreme Court is in this matter, exact matter, my lord. In postgraduate, my lord, said a supernumerary post should be created in this kind of thing. My lord, I'll place if
Sir, there are so many vacancies.
my lord, I'll
Question of when it's
check,
supernumerary
my lord, if she agrees to some, I'll not stand in the way.
Eighteenth February আমাদের কাছে যাবে। আমি চেক করেছি ডাবল চেক
চিঠিটা কত দেখাবো?
মেল আছে তার কোনো অ্যানেক্সচার নেই।
She needs 10 minutes of time to go through my learned junior mentioned the matter because my lord, we have to calibrate the entire system for tomorrow's process.
Yes, that is the reason I fixed it now.
My lord, but at 1 PM, my lord, if this is given and my lord, they show that
Can we take it up at 2 o'clock?
then my lord, I cannot bargain this with the court, my lord.
All right, do one thing. I have got one more matter. Pass over.
All right,
I'll come back just now. And one thing, petitioner, if you want to argue, I will place the matter before the regular bench. These are the vacancies available. In case you want to select one, it's all right. Otherwise, the matter will be posted for hearing. All right. This bench is taking up only for urgent determination.
My lord, I will ensure that she selects something.
No. It is her career. It is her life. You do not ensure anything. Let her take a call.
My lord.
Call item 2. Yes, please.
My lord, item 2, my lord. Item 2, my lord, I have taken instruction. My lord, this schedule is correct. It is true that from 2nd to 5th, the first internal class test is going to hand over.
Please give. Nikki.
For 6 semesters.
At the second page, the schedule is there.
Yes, 3rd of
That is 2nd of March.
The last one, semester 6.
Semester 6.
The month is first written, then day and year.
Month is first written. You're sure month is first written? All right, because I was thinking 3rd of February. All right, then it is 2nd of March.
2nd, 3rd and 5th.
2nd, 3rd and 5th.
Yeah, 2 papers each.
Can the candidates
They can
be permitted to appear in terms of the earlier interim order?
not in terms of the earlier order should come from the court. Another
Yes, orders come from the court in the same line as paragraph number 9 of the earlier order.
Yes.
7, 8, 9.
Yes. Subject to result of the petition, my rights will be open.
Absolutely.
And this will not
No equity.
No equity. This is number 1. Number 2 is the semester fees they have to pay.
Will you open the portal?
We shall open the portal, and my lord, there is a 15 days time for paying. My lord, they have to pay it within 15 days from the date of opening the portal.
We'll pay it immediately.
Examination is from Monday and you give them 15 days time. Prior to paying the fee, the candidate will take the examination.
That exactly I asked my client also.
Yes.
They said since that is in the circular, they are agreeable to even if they can pay before the examination, nothing like that, my lord.
I'll put a clause, they'll pay it before the examination.
Yes. Great.
Why keep it open for 15 days?
Yes, grateful, my lord. And
We'll complete all the formalities, whatever required, before second.
Check to payment of fees and
Yes.
they'll open it.
Open it and other
how soon can you
formalities may be complied with.
It will not take much time, my lord. On the day itself it will be open. After the order.
Yes, after the order is there in the server, relying on that you will open.
Yes.
Otherwise, no. Achha. The matter has been mentioned, citing urgency.
Formalities.
It has been submitted that the university is going to conduct an examination from 2nd March 2026. Stop. The petitioners seek for a permission to appear in the said examination. Attention of the court has been drawn to the order dated 10th of December 2025 passed by the court permitting the petitioners to allow in the examination. Stop. Paragraph. The fate of the petitioners shall abide by the result of the writ petition. Stop. Keeping in mind that the writ petition is pending consideration, the petitioners be permitted to appear in the upcoming examination.
Even semester first internal class test.
আচ্ছা ঠিক আছে. To appear in the even semester first internal class test schedule 2025-2026 starting from the 2nd of March 2026. Stop. The petitioners shall be bound to clear all formalities, not clear, abide by all formalities and pay the examination fee prior to appearing in the
No, that is semester fee.
semester fee. Semester fee appearing prior to appearing in the examination on 2nd March 2026. The university is directed to open the portal so that the petitioners may make the necessary payment. The petitioners' participation in the examination will not create any right or equity in favor of them. Stop. The rights of the parties shall remain intact. Stop. All parties can make necessary submission at the time of hearing of the writ petition. Anything more to be incorporated?
One thing, Millard. There are other formalities to be complied with.
What are the formalities?
Millard, we have to upload all the papers and documents. Even the earlier.
And everything is online?
Everything has to be done online.
Yes, they will open.
And something is offline also.
What?
Certificate is issued by
Some certificates are to be issued by the
bank will receive payment.
Then the bank will receive the payment and then they will allow us to
But
deposit
the payment is to be made.
Yes, Millard, on the basis of certain documents which we have to submit online, and the university has to give us in writing that it's okay. We will submit those papers to the bank, and through bank, Millard, the amount will be credited in the account of the university. So, Millard, there are some formalities, Millard, they will.
The university is directed to permit the petitioners to comply with the necessary formalities so that the petitioners can appear in the
Online and
test.
Both offline and online.
As a formalities both offline and online. Anything more?
No. Required formalities.
Yes, yes, all requisite formalities. Because this is what I see in the earlier order. No equity created, result, the fate of the petitioners will depend on the fate of the writ petition. All right.
But can one disposed of?
Can one stands disposed of.
Milord, there are other prayers also in Can 1, Milord. Let that be.
What is the other prayer?
Allow us to enter the
Inter classes.
classes or to Milord, prayers are there,
That is
Milord.
virtually allow the repetition itself.
Oh, I'm not saying allow that. Kindly keep that application pending, Milord.
আচ্ছা তারা dispose করবেন না, let it remain
Yes.
pending. Let us see.
I'm-
Yes. Chosen?
Yes. My lord, serial number 24 from the list given by my learned friend, my lord. This is Bardhaman Medical College, MSENT. I am not even a contender for the seat.
Learned counsel representing the committee as produced before this court a list of institutes where vacancy in respect of scheduled caste category is available. Stop. The list of institutes was handed over to the learned advocate for the petitioner. Stop. The petitioner is personally present in court and she selects the institute Bardhaman Medical College for the course MS ENT.
My lord, we have selected it as item number, choice number 5 in our
Said Bardhaman.
page number 213. Page number 213 of the writ petition, my lord, we have selected Bardhaman as our choice.
It was also her choice,
Alright,
fifth choice.
this is available and you accept it.
Yes.
Achha. As a vacancy has been identified where the petitioner is agreeable to pursue her course. Accordingly, the committee is directed to take necessary follow-up steps so that the petitioner can take admission in the said course. Anything more?
Yes, my lord, the National Medical Commission and the Central Medical Counseling Committee shall also take necessary steps to complete the formalities, because it is not for us, because there are
Alright. The National Medical Commission and the Central
Medical Counseling Committee. My lord, we are the state West Bengal Medical Counseling Committee.
ঠিক আছে লিখে নিন
মেডিকেল কাউন্সিলিং কমিটি ন্যাশনাল মেডিকেল কমিটি
National Medical
Council.
Counseling Committee.
No, National Medical Council.
Oh, council.
National Medical Council, that is the head body,
Council.
and the
Shall take necessary steps to conclude the formalities for admission of the petitioner in the said course. Is any direction required to
the college.
treat the candidate or as SC, because all along she is being treated as general?
but now after once she takes admission, there is no further no further privileges attached to being SC.
No question of privilege, but for your records.
Yes, for the your lordship may record, for the records in terms of the earlier writs order,
Yes.
she will be treated as a SC candidate.
So that has already been done. Then leave it.
My lord, one indulgence, my lord, she
Your lordship may also record as alternatively in the body of the or lordship's order that this seat in bracket SC.
No, no, that I have recorded.
Then it's still she to have a SC.
Recorded.
tomorrow, my lord,
Okay,
who is pregnant, my lord, otherwise, my lord, if a certain time be given, maybe 42 hours, my lord, because she is, my lord, running for 2 days.
No, no, 1 minute. What is the other formality to be done?
My lord,
He
she
has
has to get
go.
papers, give the papers.
Papers means
In the college.
it online?
No,
No.
no, it is physical.
So she has to go to Bardhaman
Yes.
Medical College.
Yes.
That's why, my lord,
He has to report and complete the admission formalities.
Tomorrow, she can go tomorrow itself.
my lord, she has, my lord, after the result was published day before yesterday, she took a flight, my lord, came whole night she was in my chamber, my lord.
Sir,
My lord, she is
the
pregnant,
the earlier she does it, the better for her.
yes, my lord, I understand. Kindly, my lord, allows 42 hours, my lord, if 48 hours, my lord, if she can go tomorrow is good, otherwise day after tomorrow.
48 hours goes to Saturday will be difficult.
But I'm
though I am extremely sympathetic about her, my lord, but the thing is that
I am not,
putting up in the portal, etc., my lord.
I am not fixing any time, right? The court has already passed order and the authority will take steps.
My lord, the portal না না ওকে শুধু বলে দিস কমিশন লিখে দিতে ন্যাশনাল মেডিকেল কমিশন আজকেই তো শেষ my lord in the my lord kindly comes to page my lord this is page 342 my lord কালকে this is a tentative reserve schedule NEET PG medical state quota private management quota and NRI quota my lord they say my lord today is the last day of selection. Today is the last day of
District Court's order director line লিখে দিন তো, the Burdwan Medical College is directed to take steps in terms of the order passed here in above. This will possibly help you. This single page not required, take it back. ওই যে দুটো লাস্টে নাম বললাম না, লিখে নিন।
Thing I give you, not sought for your lordship's leave in the morning because I filed in the department today in Monday's date, my lord, so that I can file it. When the department has rejected it, say with 8 number, saying instead, in spite there is a 48 hours, we cannot take on Monday unless the court directs that gives us leave that it can be filed on Monday.
So you were aware of it, what is so new about it? This is the usual practice.
48 hours, there is 48 hours, but only because of, my lord, I don't know, they are given, my lord, they are saying that for filing on Monday, in spite there is a 48 hours, Thursday, Monday, we cannot take it unless there is a leave, because my lord, Saturday, Sunday, it is closed unless the courts give.
What is the urgency?
Urgency is, my lord, petitioner's son is having CBSE examination class 10. My lord, she sought for a CCA. She has been issued a show cause that unless you join, you will be suspended. I am not telling for moving the matter on Monday, so that if you some mistakes, so I can mention, my lord, after the examination is over, my lord, for upgradation. Otherwise, my lord, it will be difficult.
Suppose it appears in the list on Thursday. Wednesday, Tuesday is a holiday.
Thursday, my lord, difficulties, my lord, if I have no problem, but in your lordship's list, if new motions, my lord, since because of the second SLST and other matters are not being taken up regularly, so my lord, and upgradation is only allowed, my lord, on the first day of the mention.
Now I tell you, Monday I'll not take up any upgradations.
No, my lord,
No, I have requested, given a direction upon my officer, and there is a note also in my list that there will be no upgradations. What is happening? The entire list is going topsy-turvy, from bottom to top, top to bottom.
Not only kindly, Monday I will not mention if your lordship.
Let it appear, you file it, it will appear on the 5th, I'll see what can be done. Don't worry about it.
Last of your lordship please to fix this matter for at 2 p.m. my lord.
It is not yet 2.